Hi everyone, you are welcome to this edition of our program. It is no longer a news that the DSS has denied the legal representative of Mazi Nnamdi Kanu visit. His lead counsel, SAN Godwin Kanu Agabi, was denied a visit to his client, who is currently facing a trial at the Federal High Court in Abuja, Nigeria. The news has circulated, but one has to explore why such things take place. In a legal system, it is the right of the detained person to have legal advisor or counsel to visit him to discuss the legal proceeding. Everyone is aware in this proceeding that the legal team of Mazi Nnamdi Kanu is led by Honorable Godwin Kanu Agabi, SAN. It is widely known that this is the lead counsel. The aim of the visit is to have interactions with the client on the oncoming proceedings on the 14th of May 2025. According to international law, the international standard, access to a lawyer must be granted from the onset of the custody to the hour when the case is discharged. According to UN Special Rapporteur on Torture, it has been noted that access to counsel is a right of the detained and must have his legal visit regularly according to the choice of the counsel representing the client. The aim is to avoid deprivation of liberty. The UN Human Rights Committee has also observed that the right to communicate with counsel requires that the accused be granted prompt access to a lawyer. That is the international standard. In my previous program, I made it clear that the criminal trial of any nation is incorporated into the United Nations human rights. This standard is extended to Inter-American Court of Human Rights, European Court of Human Rights, African Human Rights Court, West African Human Rights Court, known as ECOWAS Court. But unfortunately, it is Nigeria that do not observe these international standard regulations. But yet, they are the giant of Africa in things that are not standard and acceptable by the international community. But one would ask, what is the problem of the DSS with the trial of Mazi Nnamdi Kanu? They are responsible for his arrest in 2015. They were responsible for his abduction and rendition back to Nigeria from Kenya, and they have been detaining him since 2021 till yet. It is expected that all their legal work have been completed before going to court of law to charge him against all forms of criminality and terrorism, which is being defended in the Federal Court of Justice of Nigeria. Unfortunately, the management of the DSS and the legal team and the Nigerian authority is still finding it difficult to make their case known to the world, to defend their case against the detained person, Mazi Nnamdi Kanu. Therefore, the denial of the lead counsel of Mazi Nnamdi Kanu, SAN Agabi, to the DSS facilities is an indication that the DSS is even tired of the case. They cannot assess who will be the next masked man to testify against the detained person, Mazi Nnamdi Kanu. They are not willing to continue, perhaps, but what will they do? They are under the pressure of the past and present interest groups in government. But where they are tired, let them signify and allow the young man to leave the facility. Denial of the senior advocate of Nigeria, the 2 times Minister of Justice in Nigeria, a senator, and a legal luminary is a slide and disgrace to the legal system of Nigeria. It is unfortunate. The world are reacting. Reading this from the newspapers or from the social media makes Nigeria to be another Afghanistan operating on the law that is not recognized by the international community. They are member of United Nations, leader of African Community and ECOWAS, yet they practice inordinate system of governance, of legal system, creating embarrassment to Nigerian nationals all over the world. If the masked men are no longer interested in giving evidence extracted from nowhere against Mazi Nnamdi Kanu, again, let them leave the young man and look on how to make Nigeria great if they want Nigeria to be great, and also allow those who want to be autonomous in order to standardize the future of their children. The bickering politics of Nigeria makes it difficult for any system to work, including the judicial system. With the days, we come to the end of this very program. Let the judge judge the right thing. If it is wise for the DSS to deny a legal visit to the client Mazi Nnamdi Kanu. Again, the flawedness of Nigerian system makes life difficult for Nigerians living outside the Nigerian territory. This should be known, and this affects both those in government officials and those who are living outside Nigeria. Nigeria, leave Kanu alone and also allow the natural course of justice to thrive. Do not continue to frustrate his legal team and the legal proceedings as a way of continuous detention. Nigerian government officials and security agents should not continue to give Nigeria bad names and bad image from time to time while discharging their official duties, of which most of them are of international standard. It should be known that Nigerian officials cause more problems to Nigerians living outside because of their maneuvering power, bribery, corruption, and inordinate behaviors. These are the problems Nigerians and Biafrans alike suffer outside Nigerian territory. Follow the rules and procedures of international standard, and that will make you to be great nation you want to be, rather than striving to act like the mullahs of Afghanistan in power. Thank you very much for watching this video. Again, do not fail to subscribe, like, share, and leave your comment, which is highly regarded and accepted. Thank you, and God bless you all. We will come to you again. Bye.